Welcome to the Agent Legal Lounge, the ultimate interactive weekly webinar that answers your burning real estate practice, contract, and legal questions. Hosted by distinguished attorney John George, co-chair of the Texas Real Estate Commission Broker-Lawyer Committee, CEO and General Counsel of Special Provisions, and managing member of George PLLC. Tune in each week for an exciting, laid-back, and incredibly informative hour as John explores the Texas real estate profession, tackles hot topics requested by brokers and agents, and even takes your questions live. Get ready to dive in. The Agent Legal Lounge starts right now.
Kiersten Crawford here today as a co-host. I really appreciate all of her help and guidance. We've taught classes together, and it's been a real pleasure to do so. If you don't know Kiersten, she's a co-owner of Halo Surveying. She's a senior instructor with Texas Realtors and has been a broker for a long time. So Kiersten, thank you for being here today. I'm going to do a quick introduction of yourself.
Absolutely. I think you did a great job. I say we jump in. Let's roll.
All right. And so what I want this to be is an interactive weekly thing. If you have questions, put them in the chat. We'll try to take them live at the end of it. I have a presentation prepared to walk through that you'll have on your screen in just 1 minute. And today we're going to tackle this compensation issue, and I think in a little different way than what you're used to seeing. And what we're going to do is look at it from the buyer's perspective, right? What are the emotions your buyer's going through? And then that will help us understand it internally on how both we need to explain it and what all these new forms with all these new numbers and new blanks, what they actually mean. What do they mean on boots on the ground? So we want to simplify and understand what we're actually doing. And then that will help understand all this new legal mumble jumble that's in the documents. So to jump right in, we're going to look at this from several different perspectives. First is how much, and this is from the buyer's perspective, how much am I willing to pay my agent? And what does that mean for us as agents and brokers? Then we're going to look at, you're asking me, this is a buyer, you're asking me to sign a contract? What's in that buyer's rep? What does that actually mean? What is it doing? And then we'll look at how to address the commission on the seller side from the buyer's perspective. Who's paying at the end of the day? How are we going to get part of my commission that I owe you, broker, now? How am I going to get that paid? So we'll walk through from multiple different levels and get into the actual forms. But today, just remember, we'll be looking at it largely from a buyer's perspective. So let's look at it first to see how much am I willing to pay my agent? And historically, the buyers have expected, whether this was legally right or wrong, that, well, the other side's going to pay the commission, right? I'm going to sign up and the other side ultimately will pay. And they never had to worry about that of, at the end of the day, having to come out of pocket to pay anything. I'll note that the buyer's reps have always had this provision in there that the buyer will pay. That's not a change in practice in the forms. Now, the forms weren't necessarily used that often, but the forms had that in there. And it always said that you would go seek a credit from the other side. But we as brokers, if we use the form, have always had that in there. We just didn't have to explain it. And when I say we on these things, I've been an attorney for 16 years. I've owned a title company. I've married to a broker that when I was a baby lawyer said, just shut up, stop being a lawyer and let's get the deal closed. So I've seen this from a lot of different perspectives and as a buyer and seller as well. And so I try to look at all those perspectives here. And when looking at how much to charge, it really is a personal and business decision. And so when a buyer's going into this discussion with buyer's agents, they have to look at, what am I paying for? What am I getting? And the broker has to look at, what am I offering as a service? How much can I charge for it? What's the value there? And we think of it, generally speaking, as full service brokers that provide complete service from the looking at houses to closing. That world is going to change. And now brokers can look at, do I provide limited service? Do I only show houses? Do I only do this subset of work? And how much risk am I willing to take on with the buyer that may not be able to pay at the end of the day? And so it really needs to be an internal analysis on the business side that historically we haven't had to do. And in looking at the business side, there's multiple different ways to charge. You have, of course, the two big ones of a percentage or a flat fee, but you can do hybrids of the two. You can do an a la carte menu of services with different charges for different aspects of it. You can structure these things just like any other business in many different ways. And you're going to see brokers being very creative in how they charge and come up with different methods of gaining business by breaking that down rather than just a full percentage or a full flat fee. The one thing to keep in mind with the new changes as you look at these business decisions is that it has to be a conspicuous and specific amount. It can't be open-ended under the settlement. And so I always say the easiest way to remember that is your agreement has to have an A plus B equals C. It can't be A plus whatever amount I get from the other side equals C. You have to have a definite amount that you're charging the buyer that they can determine up front. And it has to be capped. Under the new rules that are out with Texas Realtors or NAR, you have to have a cap on that. So you can't have that open-ended, I'm going to collect more at the end of the day if they're offering more than I'm charging you, buyer. Now, there's a ways to amend it later on that we'll get through if a situation arises that you may have the opportunity to collect more from another side. But your agreement up front with that buyer has to set a cap. Now, doesn't the seller have to pay? You know, you're going to get that question from buyers. Doesn't the other side pay? They always used to. Well, possibly. Everything is negotiable still. The big thing that's no longer out there is this MLS offer compensation that made it easy. But that same procedure is available through other sources that we'll go through. So in every deal, whether the seller's saying, I'm willing to pay or not, it's always negotiable. And there'll be other vehicles to take advantage and establish that relationship where the seller pays or the listing broker still pays. And so the next one is, remember, the buyer agrees to pay regardless. That's a really big change here that you have to get prepared for that discussion. The buyer at the end of the day with the contractual relationship has to agree to pay. And we'll get through the different methods of how to potentially have that discussion at the end, but you'll have to know how to sell your worth. And there's lots of different reasons we can go through why you're worth what you charge, but you have to think about, am I worth that? How am I selling that? You have to be genuine and honest about it.
Yeah. So
The
John,
buyer's thing,
I would maybe add one thing, you know, in talking on that previous slide you were just showing, is that I think it's just a shift in our perspective about the representation agreement, because I think agents used it for establishing agency, but didn't always hold them accountable for the compensation piece. And now we have to. Any thoughts on that?
yeah, and this is where the form had the legal language in there. It's always had it where the buyer was responsible. But as a profession and as a practice, a lot of buyer's agents never held the buyers accountable if they didn't collect the full amount that was in there. We had great forms here in Texas. A lot of other states, and this is a national lawsuit, a lot of other states didn't have our good forms. But our practice didn't match the legal language. And this is a good point of that buyer's rep largely wasn't gone over word for word with the buyers. And a lot of us as buyer's agents didn't know what we were having our clients sign, to be quite honest. If you asked many agents in the old form, did you know that was in there? And a good number would say, I didn't know the buyer was absolutely agreeing to. Now, a lot did, but that's another thing that is just, if it was used, it wasn't understood. And now we're forcing, I think it's a great thing at the end of the day. It's not going to be easy up front, but I think it's a great thing that we have to explain it to our buyers, because we are legally obligating them on a contract with us as the broker. And no longer can we say, just sign it and we won't hold you liable at the end, right? They have to know going into it that it is a true legal obligation. And under the NAR ethics rules, we have to go into it that way. And we can't look at just sign it to get it past the auditors like the old Enron, thing was. Just sign it. right? And that goes against the ethics rules. It goes against your fiduciary duty to your client. Just sign a document, I won't hold you to it. We can't do that, and we never should have, but now we're having to pay attention to it. So the next one, they're saying, well, you're asking me to sign a contract. What's actually in it? Why are you having me sign this? And the big thing with the buyer's rep, and we're starting at high level, we'll get down to minutia in a little bit, but it protects both sides. It sets the outer bounds of what you're doing as a broker for that buyer. And it lets that buyer know exactly what you're doing for them and what the economics of the deal are. So when they're considering future deals, they know going into it, here's my bottom line. Here's what I'm looking at paying. Here's how much I'm going to have to put into that house. And again, you can be selective in the services you provide. It doesn't have to be the full service. If it's just showing houses, and there's options now in the short form for just showing, right? I know this is what I'm into it for. I always liken this to attorneys, right? Attorneys are, a lot of clients get surprise bills at the end of the day, bill by hour, and oh my God, I spent all this money, as opposed to a flat fee of, I know going into it, this is that amount. And so having that discussion up front, having that certainty and doing it, whatever way is a business decision for both parties makes sense. And the rules that are out there now are really to provide clarity on that exact legal issue. The next one is just to note that you're going to have agents out there that are not members of NAR and Texas Realtors. And they're not bound by this requirement to have the buyer's rep agreement in place. You're going to see that. I think NAR and Texas Realtors are great. There's so many great things they do, both for consumers and for us as realtors. But you're going to see others that say, you can come with me and not sign one. And that is still legally permissible under TREC rules. There's no TREC rule saying you have to have a buyer's rep. So you're going to have some of your competition out there potentially doing that. Now, I think it's definitely in the best interest of all parties to do it, but just know that that's something that might exist. The easy thing, well, you're asking me to sign this now. When do I have to sign this? When do can't we just look at the house? Can't we do X, Y, Z? The target black and white line, and what they use in the settlement and the rules, is before touring a property, which in Texas we generally know as showing. In other locations it's known as touring, and that's used a little more often. But that's the black and white line that you need to have a buyer's rep in place before showing a house. And so be prepared to have that discussion up front. And there's a couple different forms that you can use, a short and long form. And that's actually the next bullet point. What form? Well, you're asking me to sign a form. What are my options? The buyer, what is the documents I'm looking at? Well, there's no specific form, even under NAR and Texas Realtor regulations or rules. They don't say you have to use their form. And in fact, you're seeing a lot of brokers out there develop their own. Some that are just as simple one-pagers as the short form from Texas Realtors, some that are longer than the long form, and a whole lot that are in between. And so this is where I think that part of our business as a broker is being analyzed very closely for the first time. And that's, again, a good thing. You need to understand what that relationship, the contractual relationship is with your buyer. And so as a broker, take that into account and have a serious consideration of, what am I getting them to sign? Do I want my own form? Do I want to use one of these two Texas Realtor forms? And what's in there? And I would say, as a high level, the short form lacks a lot of the protections and additional legal clauses as a long form. I think it will be used mostly if you're quickly showing a house to somebody to get them to sign up to see that house, and make sure you limit it properly. So you're not agreeing to, show property in the whole state for XYZ flat fee or whatever you put in there. But the purpose, I think, largely practically speaking, was to give a vehicle to show a buyer a house quickly, and not to have them say, I have to sign a 4-page, 3-page contract to see the house. And so it's a vehicle for you to be in compliance. The longer one has a lot more terms. It has a lot more protections, a lot more things written in to remove ambiguity. And so take a close look at those forms, and we'll go through some of the provisions in a little bit. And just know that you have to have it in place before showing a property with to a buyer. And as the brokers, all the brokers on here, take a serious business look on, do I need my own form? How's this discussion I'm having with my buyer? Does it match up with what's in the buyer's rep form? Do I want to have it flow differently to be more of the conversation I want my agents having? Does it provide the protections I want as a broker? And so that part of your business it's a long time coming to look at that to make it fit what the rules are. So next up, well, what's in the buyer's rep? The buyer's gonna say, let's go through it. Let's see what the actual terms are. And so looking at this, I'm going to assume we're looking at the actual Texas Realtors agreements, not a custom form. The full service part of the Texas Realtors buyer's rep, if you look at the broker obligation provision on the first page, what is a broker? What are you as a broker agreeing to do? You're agreeing to use your best efforts to assist a buyer in acquiring a property and negotiating a contract. You're bound by all the TREC rules, right? So all the TREC rules behind it, but the contractual obligation is for you to use best efforts to assist the buyer in acquiring the property and negotiating a contract. Now, if you're doing the limited service under the short form, the showing only, you're agreeing only to provide access to properties, right? You're not agreeing to assist them in acquiring that property or to put in a contract. But one thing that's not written into these agreements you have to keep in mind, and this is for your base fiduciary duties, that regardless of how much you limit it, and if you're using Texas Realtor forms or you use your own form, you still must do these next three things, regardless whether it's written in there or not. And all that's meet your fiduciary duties, your minimum fiduciary duties under TREC rules. And that includes conveying any offer received. This is maybe a unique situation. We're going to see more of it now. But if a seller makes an offer to a client that you're representing under a showing only agreement, you have to convey that offer to the buyer. You can't let that sit in your email. You can't say to the listing agent or the seller that sends it, sorry, I'm not representing the client on that level, so I'm not conveying it over. You can let them know you have limited representation, but you still must convey that offer over to the buyer. The second thing you must do is you still must disclose any material information related to the property. That's a base fiduciary duty that you have to do. So if the buyer asks, do you know about any issues with this property? You can't not tell them about any material issues, an issue with the foundation, an issue with the roof, whether it's on the seller disclosures or not. You have a duty to inform your buyer of those material issues, despite how much you limit it in the buyer's rep agreement. Now, looking at the source of compensation.
Okay, John,
right,
I got to stop you there because I can't believe you've gotten this far and haven't mentioned it yet. Can you note where those three duties, can you talk about the IABS and the fact that that's where you see those duties?
Yep. So the IABS is a great form that everybody should read 10 times if you haven't already, and then do that every few months. One of the things that this settlement has brought out is a general lack of understanding of agency and where our duties flow to. And when we're representing a buyer or a seller, or we're a sub-agent of one or the other, we have certain duties, and those duties are laid out in the IABS. And we have the TREC rules that establish the duty of fiduciary duty, duty of competency, duty of integrity. You have these duties that go to your clients that are a base level, and the IABS explains what those duties are. And one issue that is going to creep in with agency here is knowing who you represent. When you have buyers that are going to be unrepresented buyers out there, and they don't have a direct relationship with the seller, but if you bring a buyer to that seller and you're not representing the buyer under a buyer's rep, you are effectively representing the seller as a sub-agent. And you can go into about an hour-long, 2-hour-long class on agency there. But just know, if you're not representing the buyer, you do not have a buyer's rep in place, you're a sub-agent of the seller, if you're not representing them directly, and your fiduciary duties flow to that seller. And don't be careful not to get confused of then conveying information over to the buyer, thinking you have to advise the buyer on things. And in fact, stepping into giving them advice that may get you in trouble at the end of the day. And I say in trouble of stepping over the line when they ask, well, how many days should I put for the option? How much should I put down as earnest money? Unless you're actually representing that buyer, you shouldn't be providing any of that advice. And if you're putting a deal together as a sub-agent and seller, your duties are over there on the seller side, not the buyer. And to let you know, in these things, this would be a weekly thing for us to have a discussion, to have a very relaxed way to go over these things. And we'll go through these topics in more detail, and as we have more time to really pierce through them. But that's Kiersten is great to bring that up here, because that is a big issue that's going to arise, and to just remember where your duties flow to at the end of the day. And the source of compensation, right? So we already established that the buyer has to pay under these agreements. The buyer's agreeing to pay. One thing that's overlooked commonly, historically and today, is under the long form, the buyer or the buyer's agent agreeing to seek payment from the other side, to actively try to get the seller or the listing broker to pay. And so that's one of the things that you as a broker are agreeing to do. And so these deals, whether they're offering cooperative compensation or not, whether they're offering concessions or not, we have a duty under these contracts to seek it from the other side, to ask the question. And this is a contractual duty that we're agreeing to. Now, if we receive any amount, we're agreeing to provide a credit to the buyer. So if we receive any amount from the buyer or the seller for our compensation, we're agreeing to credit the buyer for that amount. And that's the same in both the long and short forms. The one legal nuance, which I don't think makes a big practical difference, is the short form. You're not agreeing expressly to go seek the payment, right? It has similar language in there, but you always must credit it, even under the short form. And I think they practically did that for these arrangements where it's a $50 showing fee that they didn't want to create, and I'm assuming here, they didn't want to create an obligation for you to actively seek that $50 from the listing agent when just showing a house. It just practically makes sense. I don't want to put words in Texas Realtors' mouths or speak for them, but that's why I see the little distinction there. But know that generally you have to actively seek the other side to pay part of that commission or that commission, and that if you receive anything, you're agreeing to credit it to the amount the buyer owes you as a buyer's agent.
Okay, we got a question. So the question is, if you have only executed the short form for showing services, can you still end up as a sub-agent for the seller? So maybe you need to talk about permission for sub-agency and whatnot.
Yes. So if you are representing that buyer, your fiduciary duties flow to that buyer. And to the extent that you want to represent the seller in any case, that then makes an intermediary relationship. And you have to look at when your duties may have ended to that buyer and what the arrangements there. Let's say you no longer represent them, you show the house and they moved on. Do you have any continuing obligations? What's the term of your buyer's rep? When are you officially not representing them anymore? To the extent you have any representation of them and you want to be on the seller side too, then it's an intermediary. It's not a sub-agency, because you're not just a sub-agent of the seller, you're now representing both sides. And that's where it goes over to intermediary, which this is a very big issue as well on doing intermediary right. It's effectively almost impossible, except for a very limited situation, to do intermediary without appointments. You cannot give any advice or opinions with intermediary without appointments. If they ask you how much to put in a blank, how much money should I put down? What do you suggest for the option period? You can't tell either side. Mm-hmm. The very limited scenario where that works, and I think it may have been Kiersten that gave this example of you're sitting around a table with good friends that all live in the neighborhood with you. They'd come to you saying, we already reached an agreement. Can you do the contract for us? Or let us know what the contract is. And you get around the conference room table and you go the first blank, okay, what did you agree on this? What did you agree on that? And to the extent they ask you, how much should I put in there? You can't do it. You'd say, like, you have to tell me what to put in this blank. Circling back, the second way to do intermediaries with appointments. That requires the broker and 2 agents, and an agent representing each side. And there's intermediary, a couple hour-long classes to get into on the minutia of that, because there's certain things you still can't do. 4 tenants you still must do or can't do. But then, by and large, you can give advice and opinions when you have intermediary with appointments.
So I'm going to wrap
circling back.
I'm going to wrap up that conversation, and what I read in between the lines is intermediary without appointments, in my opinion, is a bad idea. It's lots of opportunity for liability, in my opinion. And I will tell you, in speaking with brokers across the state, many of them are reevaluating their policies about intermediary without appointments. And so I would encourage you to do that. Keep rolling.
Yep. You're a paper pusher essentially at that point. And know if ever a complaint's made, let's say you have a crazy client that makes a TREC complaint that's completely off basis. TREC will get the communications. They will get the emails. And it may be a complaint not related to this at all, but they see an email where you have intermediary without appointments that you said, put 7 days in that option there, or put this much earnest money down, or this is what I recommend. That's then advice. And so it may be a crazy complaint that's dismissed on other grounds, but they see that, then you have a potential license issue and a potential valid TREC complaint that the complainant didn't even make. It's just TREC looking at the documents. So be careful of the trap that you can get yourself into with intermediary there. And if you're representing the buyer to any degree, your fiduciary duties flow over to that buyer. And you are not representing the seller unless you properly establish an intermediary relationship. So how do we address the commission, right? This is the big elephant in the room. And I'm staying away from number. Every time, as much as I've been through this, all the classes I've done, all the clients great clients I have, and I see a lot of them on this call. And we have, of all that, the numbers still make my head spin. I can get off the phone and 5 minutes later, what was the 2406, 2701? It's confusing. And so I'll circle back to the numbers after this. But let's look at it from a high level understanding. And how are we going to discuss this with our clients? Because practically we're not telling our buyer, you need to do the 2406 or you need to do 2701. They're going to want to know the substance of what's in there. And why is it important first of establishing a plan with the buyer going into it? It's because it impacts the buyer's bottom line. How much are they going to be responsible for paying? Depending on how it's structured and how the other side either offers a cooperative compensation or a concession that may impact it, they're agreeing to pay your commission. And so you need to have this discussion up front of, here's the bunny trail, here's where we can go down. If we hit this block in this structure, here are the options. But it's important because at the end of the day, it impacts what they're paying. And it prevents surprises, right? If we have clear and enforceable agreements, it prevents surprises. And then you keep your client happier, they'll know up front, and you'll both have a clear understanding, even if you don't understand the forms and the numbers, a clear understanding of what's happening in the deal. So starting with the basis that the buyers agree to pay X amount to you as the buyer's agent. Well, where can that come from besides the buyer? And there's 2 main options. We'll start with the first one of the listing broker. We had the listing broker or the seller. That's the 2 big categories of how that buyer can get some kind of contribution to pay what they've agreed to pay you. The important thing from a listing broker is to establish it before executing the contract, or at least at the time you execute the contract. And there's vehicles to do this. Texas Realtors has provided you tools to do it. Before we get to those tools, why is it important? Well, from the listing broker, if it's cooperative compensation between brokers, all the contracts except the farm and ranch do not have a enforceable agreement between brokers. The TREC 1 to 4, the condo, the new homes, the unimproved, it's just a disclosure, an informational item on what the other agreement is. And in fact, some of these new Texas Realtor forms have just an informational disclosure. They're not, a lot of them, the brokers do not sign. The brokers are not parties to the contract. So if you go into a transaction assuming as a buyer's agent the listing broker is going to pay you something and they don't, And they say, well, we never had an agreement. Well, you just harmed your buyer at that point, right? They were looking at the economics of that deal, that I was only going to pay X. And now because of you, buyer's agent, I'm not going to get this contribution. Who are they going to be mad at? Who are they going to look to for that payment? So we have to be very careful as buyer's agents of establishing agreements up front with the listing broker. So we don't enter that situation where they're not getting paid at the end of the day, or the listing broker's not paying what we thought they would have. Historically, this was done via MLS. It made it real easy, right? The MLS was the contract. That was the agreement. Whether you realize it or not, there's a lot of the boilerplate small terms in the MLS agreements that established an enforceable agreement between brokers and said how you accept it, when you're entitled to it. That's gone away. And that's where it's really important in this new world to understand these agreements and how to get them binding between the brokers. One of the vehicles for that will operate a lot like the MLS. Some of the brokers are putting it on their website in a similar fashion that has terms to, here's what we're offering on this particular property. And the important thing with that is to understand the terms up front. If it is offered on the website, well, what is the exact offer? What am I agreeing to with this other broker? You know, contracts can be written on a napkin and potentially enforceable, or they can be 100 pages long. But when you enter into a contract with the other side for them to pay you something, make sure you understand those terms. And they're so different right now. We're into a new world where brokers are drafting a whole lot of different forms out there, and it's very confusing. Before you sign something, before you tell your client, I'm getting XYZ, make sure you understand it first. So look beyond just the offer of, I'm giving X% as a listing broker for buyer's agents. Well, go behind that. Well, what is X? When do I get it? How is it established? The next one that is great that Texas Realtors has provided us, and we'll get, again, deeper into this, is the 2402. This historically was known as a registration agreement between brokers. They retitled it compensation agreement. But it's a great agreement to establish that enforceable contract between brokers up front. And you don't have to wait to the time of the contract to sign it. This is where you bring a buyer and say, listing broker, confirm how much you're willing to pay me in this written document. It's not on your website. I know you told me orally, but I need something in writing from you. So I have confidence going into this with my buyer that you'll pay it at the end of the day. And be careful for the listing agents out there and brokers that are on here. Oral agreements between brokers are enforceable. They're risky. They're very risky, but they're enforceable. And why are they risky? Because what are the terms? It's a he said, she said at that point. And I think a lot of us get caught up with the rules that between us and our clients, meaning the buyer or the seller, you get a commission, it has to be in writing. Texas law says those agreements have to be in writing. But between brokers, they can be oral. So that 2402 is a great document up front to say, I'm bringing a buyer, let's get this established to take this out. So there's confidence. My buyer's, willing to make this offer on these grounds because they know you're going to pay me at the end of the day. And that's going to be a credit to what they get. Now, the farm and ranch has had unique language for a long time that actually establishes an enforceable agreement between brokers. For the TREC contracts, it is the only contract that the broker's ink ever touches. Their only signature, that only document they actually sign from TREC, or the TREC contracts. Why was this done historically? Well, there was a lot of properties, farm and ranch properties that were not in MLS. So there wasn't that vehicle to establish that relationship. There was a lot of buddy deals, a lot of handshake deals that there needed to be a vehicle to confirm, just like we're talking about for the concerns of the buyer, that that's going to be paid. So you'll see that box on the farm and ranch as a ratification of fee. And it's limited, saying that the brokers are just ratifying what they previously agreed to, right? There still contemplates a previous agreement, but that's a vehicle in the farm and ranch to confirm it. So if you had that oral agreement or you had the separate agreement, you can confirm it there in the farm and ranch. Now, we looked at doing the same thing recently in an 11-hour meeting on the Broker-Lawyer Committee. It was 7.5 hours one meeting, 4 hours another day. And It was an exciting meeting. I've been on the committee for 8 years, and I'm the co-chair now on the attorney side. It was the most exciting meeting we've ever had. And it's more like a reality show in many aspects with how passionate everybody was. And to show you how hard this issue is, we had a lot of votes that were 6-7, or there's one, I was the only one that voted one particular way. You have a lot of independent, strong-minded individuals on there that are making the soup of these contracts, that are trying to figure this out. And we looked at it from every which way. And I always like to point to the meeting materials. They're hard to show up on here. This is all your comments. We read every single comment that you send in. If you send one to general counsel at TREC email, we're going to get it. And we looked at all that. And ultimately, we decided not to put the farm and ranch language, or at least not recommend it to be in the farm and ranch language in the 1-4 of the other contracts. What we kept the informational only disclosure, and that's the way it's always been, just informational. I think some agents have a misunderstanding that if you put in the last page of the contract in the 1-4 that this amount of commissions being shared, that it was enforceable. And in fact, we added language fairly recently to say, no, it's not, it's informational only. You know, I'd add to the tagline to just reiterate that, but know that that won't be enforceable anytime soon. What we did do, which we'll go over, is we're making a suggestion to TREC that they'll take up on Monday, that we add a concession field in paragraph 12. I'm gonna get too off track, but a concession field in paragraph 12, where the seller can make an enforceable agreement in the contract to pay the buyer's agent up to a certain amount. But the thing with the concession is it's out of the seller's pocket. Just remember that concession doesn't appear in paragraph 12, but that's what we know it as, right? That's out of the seller's pocket. What we're talking about here is broker to broker. What is the listing broker agreeing to pay the buyer's broker? And that's what's important to be established up front. So now let's look at it from the seller. You know, the seller may be part of that pot, right? Buyer's agreeing to pay. We saw how we might be able to get from the listing broker, but we know a lot of them out there a lot of listing brokers are not going to offer it. In fact, I think EXP's new agreement says we're not offering any amount to contribute to buyer's agents. Now, that doesn't mean they won't, right? Everything's still negotiable. I would say for everybody, even EXP, if they have that stance, it's still negotiable, right? Some might have a firmer stance than others. But if that bucket's not available, or even if it is, and it's a deficiency, right? The seller can still pay the buyer's agent fees and the compensation there. And there's vehicles to do it. One of the great vehicles is the addendum for broker fees, right? We had that new 2406 to throw in a number there. There's addendum specifically provision in there specifically for that. We also had the new not necessarily new, but the 2401, which is what we used to use for FSBOs, right? For sale by owners, you know, making sure that the agreement was there to pay. And so that establishes an agreement to pay on that, where the seller's agreeing to pay directly the buyer's agent. And then the other ones is, you know, possibly paragraph 12, which I went over, you know, that might be an enforceable provision there. But those are the three big ones, is the addendum regarding broker fees. The farm and ranch right now has that provision at the end. It's baked in there where the buyer or seller can agree to pay the fees. And then possibly in the future, the farm and ranch. But we'll look at the Texas Realtor forms here in a minute, and we'll get into the options that are in there.
Let me add one thing too, John, just because I've heard from a lot of brokers over the last 10 days now that they're in practice. And I want to caution the brokers and supervisors, especially, to really have conversations with your listing agents, because what I'm hearing are conversations like, the listing agent told me that X% was being offered, but when the buyer's agent really pushed for the form, they were like, oh no, just submit it with the offer. The seller wants to look at it when the offer comes. So don't make assumptions that we're in the old world and the seller's always going to pay. I think we need to make sure we're emphasizing those agreements.
Well, and I see from Amy Arnold, great question in the chat, right? So can we address 2401? That is what our brokerage is doing. So should we send that with an offer? Well, here's the risky thing of sending it with an offer. let's say everything else gets signed except that 2401, right? So you have the contract that your buyer's assuming the terms that are X that are going to include this contribution in the 2401, but it's not signed. Well, then you don't have that enforceable agreement potentially with the other broker, but you still have an enforceable contract. Remember, it's not, unless it's made contingent somehow on the 2401 being signed, if you don't have it signed up front, then you may be out of luck. And so just by sending it over, and we'll go over the 2406 that talks about the 2401 language, but you need to make sure it's executed first, right? And if you send over a signed contract that's signed by your buyer, and with that contract in the 2401, that contract can still be signed and binding, and that 2401 never gets signed. And that puts your buyer in a very potentially bad situation, right? That they can be paying more than they expected to on that particular deal. And that's why it's so important, going back to that, to get it signed up front. You get it signed before you create that binding contract between the buyer and the seller. And actually, that's in looking at the 2401's with the seller itself. So I was talking about the 2402. This is where the numbers get spinning around, but the same logic applies, right? So unless somehow you make it contingent upon the seller signing that 2401, if they don't sign it, it's not a binding contract, and it hasn't been made contingent. You have to sign the whole contract plus that. So if they sign the other contract, that still could be binding, or still would be binding. So it's good for both the 2401 and the 2402 to get them signed up front before the contract.
Did you see the second phase of that question, which is, what if we list it in paragraph 22?
So if you just list it in paragraph 22, right, it hasn't necessarily, it makes it part of the contract there. So I would feel better if it was listed in paragraph 22. And it's not expressly contingent, but it's part of the contract itself. And so putting my lawyer and practical hat on, it's not as good as saying you have to execute it, but it is by listing it there, making it part of the contract. And I think the legal answer there would be that if you don't sign the whole thing, you haven't executed the whole contract. Similar to if you check the third-party financing addendum box, and it's all sent over with the offer, but everything comes back without the third-party financing addendum signed. Well, there you don't have a completely signed contract. But that doesn't prevent arguments from being made. I hate, the one thing I hate and love in different ways, you don't have a lot of attorney involvement with residential real estate. And so you get a lot of arguments that are not necessarily fully informed on the legal side. And so somebody might argue, it's just in paragraph 22, we signed the core contract, and we're gonna have to work that out separate. Or, hey, the third-party financing wasn't signed, we're still under contract, we just have to now go get that signed. You know, not that it created a situation where you can be revoking the offer or something like that. And I say I hate the fact that there's, you know, hate and love that lawyers aren't involved, because they can gum these deals up just as much as anybody else. And there's not too many that truly understand the minutia of these contracts. So when a good, competent lawyer pops up, it's great. A lot of them out there aren't. So I think legally speaking, if you put it in paragraph 22, it would create a situation where they would have to sign it because it's part of the contract. But you put yourself in these practical situations where one side might not see it legally that way, or the other side might create a legal argument that's opposing what I think, and then you're stuck at, well, how do we make sure who's right? And you don't really fight these cases because of the economics all the way through the courts. That could take years. So how to avoid that situation, how to not put your client in the potentially bad situation, is to get it executed up front. Can you do that? I think you can. I think you'll be legally right at the end of the day. It just could be a difficult situation for you and your client. And so, you know, looking at the other considerations of amending the buyer's rep, you know, what situations could arise that you might want to amend it. And that's one common thing that a lot of people have brought up are the bonuses, right? And I'm offered a bonus here. The underlying buyer's rep agreement gives a notice to the buyer that, hey, I may be offered bonuses or other compensation, but it doesn't specify the amount. It doesn't say, here's what I'm willing to accept. None of the rules, you can't put that in up front. So when that situation arises that you are offered a bonus, then you have to go back to your buyer and say, authorize me to accept this. and it becomes a discussion with your buyer at that point. And if you've done a really good job and really kick butt for that client, they'll be more apt to agree to it and to allow you to accept that. But just know if that arises as one situation, you'll need to amend it. Another one is for additional compensation. Let's say you agreed to X with your buyer, but they're paying more on the list side. They're paying Y. Well, you can't accept that difference. You can't accept all that Y without amending your buyer's rep. Remember, the buyer rep creates a cap. And now you're going to have this situation where your buyer says, well, I don't want you to get that. Give that credit to me. You've already agreed to work for X. And that's what the DOJ was getting at with these lawsuits and inflation of commissions. You've made a business decision up front that you're willing to do the work for X. And if you're going to change that now, and just because somebody else is offering it, you should have a justification for doing so. Right? Your service has already been established that this is your worth. Now you may have done a whole lot, and that buyer may agree to it, but that's the situation the DOJ, rightfully or wrongfully, I think is looking at it at a high level. And so if they're offering more on the list side and you only have a lower amount in your buyer's rep, you'll need to amend it at that point. And we talked about this a little bit already, so not to go too much into it. Remember, concessions out of seller's pocket, commissions, cooperative compensation out of the listing broker's pocket. In that you're not required to disclose. This is another big one. Not required to disclose your buyer's rep. A lot of people are saying, a lot of listing brokers, you have to show me your buyer's rep. Right? I want to know before we go to closing that you actually had your buyer agree to that amount. Well, there's no requirement for you to provide that document to the other side, period. It's not confidential by its terms, but it's a private business transaction between you and your client. And so the question arises, well, who's going to enforce this? Who's going to know that there was that actual agreement for the buyer to pay this amount? And unfortunately, and practically speaking, it's going to take complaints. It's going to take somebody taking the next step in these situations that then gives rise to the ability of Texas Realtors to ask for these documents, or for TREC to ask for these documents under the authority that they're granted. The title company cannot request it. Texas Realtors or TREC without complaints can't ask for it. It's not going to be an easy way to police it. And this is where, as a profession, we need to rise above. We need to meet our fiduciary duties and be ethical. Fiduciary duties, remember, are not only to our clients. We have to treat everybody fairly and impartially. And if we're misrepresenting what our agreement is with our buyer, that's an absolute breach of fiduciary duty. And so remember, fiduciary duties are broader than just to our client. It's treating everybody fairly and impartially. And if you're misrepresenting things, you're absolutely breaching fiduciary duty to your client, but you also are to the other side. So avoid gamesmanship on that. Don't get yourself in that trap of misrepresenting things, because it can turn into a serious issue at the end of the day. Now, I do want to jump into a little bit of the actual form language. And so this is the 2406 section that's displayed on your screen right now. And what I'm referencing is the 2401 and the 2402, historically known as the registration agreements, now known as the compensation agreements. One being between brokers and one being between the broker and the seller. And there's a lot of confusion on here on this being enforceable. There's, I think, a lot of agents there, and reasonably so, think if I attach this addendum to 2406 to the contract, I'm protecting myself all around. I'm establishing the agreements for who's going to pay what at the end of the day. And there's actually only one enforceable compensation section in here. And I try to break it down on this screen to show you which ones are enforceable and which ones you still need that outside agreement signed. And so if we look at the first one, and this is under Section D of the 2406, we have D1, where the listing broker is agreeing to pay something. All right, so it starts off, listing broker shall pay. So this is the broker. And it says that they'll pay blank, but I highlighted the very important language you have to focus on. They're agreeing to pay it in a separate agreement, separate written compensation agreement. And then it says such as the 2402. So if you get this signed, that box checked, you still can have that enforceable contract. And this is just separate agreement that you needed to get signed up front, that you needed to get signed to establish that arrangement. This is just disclosure. And in fact, down here, if you look in that bold language at the bottom, just where my video is, it says it's for amounts in 1 and 2A are informational only, and do not change that separate written agreement. The second one there, we jump into section 2. This is the seller paying. It's out of seller's pocket. First one is listing broker's pocket. Second one's out of the seller's pocket directly. And the first option, I put it in yellow to make it similar, is again, they're agreeing to pay X in a separate written agreement that's signed. And that in that particular case, they give the example of 2401. Doesn't have to be that agreement, but that's the Texas Realtor form that's available for it. So again, you would need that separate written agreement signed. You can't rely upon just that box. The green one, you're good to go if you get this signed. The green one, the seller's agreeing to contribute X amount, similar to concessions, right? This is that concession paragraph we were talking about. So if the seller signs this creates a new enforceable obligation. You don't have to look elsewhere. This establishes what the seller's agreeing to. So the first, if you do 1 or 2 there, you need an agreement signed outside the contract. Disattaching this addendum is not sufficient. Under B, put it in green, you're good to go. You have an enforceable agreement between the seller to pay a portion of those buyer agent fees. And I think if you have something like this to reference, and in future episodes, we'll get more into language like this in the contracts, but I wanted to circle us back to that conversation in this one to say, what's your buyer thinking? The buyer's not going to want to hear 2406, 2401. Tell me what I need to sign. Tell me what this actually means. So circle back to the conversation, get that straight. And then we're going to have some really good tools that we'll provide to you on packets of, if in this particular fact situation, what is the scope of documents I need to look at? Both the contract and the Texas Realtor forms, or if it changes a little bit. Now we're getting, let's say one situation there, the listing broker was paying everything. Well, another situation where the listing broker is only paying X and then the seller is making up for it. Have your packet ready to go. Don't have to go back and look at the forms every time, because looking at all these new forms every single time is confusing. It is, if you don't have some ready reference of, here's an easy fact situation that I can understand and that I can explain to my client and have my client understand. If you don't have that there, then it's going to be hard going straight to these, because these are confusing. And then behind that, you'll know, oh, here's the packet for that fact situation of what I need to look into. That, I think we'll dive into that in future episodes. We'll provide those materials to help you out as one of the options for each one of those fact scenarios. But that's how I would look at this particular situation. And we have a few minutes left here. Today, this in the future, sometimes I'll have guests on, sometimes we'll go through discussions. Now this compensation issue is so big, I don't think we can hit on it enough. With that, Kiersten, I don't know if you've any more questions come in, or if anybody wants to jump in.
Yeah, I had a few in chat that I addressed. If you want to take a peek, and then I'll just poll the audience. Okay, guys, we've got an attorney who has a clue. So any questions? There we go, Betsy. So D2B would be used if the listing agent does not submit 2402 prior to a buyer agent submitting an offer. Yes, that would be an option. So let me clarify in practice. So in practice, you're trying to get a hold of the listing agent. Maybe you can't get a hold of them. And so you can't get any separate agreement signed, 2402 or 2401, but you're trying to get your offer in. You could use D2B. Now, how it may unfold is they may go, oh, now I'm paying attention as a listing agent and I actually do have this form, and then they send it over. I believe I'm already hearing that happening. John, anything else to add on that?
No, I think that's exactly in practice. You have to look at for your buyer. And if you don't have it established in the 2402 or 2401, that 2B is a place to establish it, to have that firm agreement. And the 2401 is the one that's actually between the seller and the the buyer there. But either one, if you don't have it established in 2401 or 2402, yes, 2B is where you make it enforceable and provides the clarity. If they were just to sign it right there, you have clarity for your buyer because it is an enforceable agreement.
Okay, there we go. I put my phone number in there. I'm having lots of conversations. As Johnny, if you'll read that chat, I'm having lots of conversations with brokers right now. And so y'all let us know what's going on. Let's read that one and see what you got.
Yep. And so the first question that pops out there, do you recommend using both the 2402 and the 2406 together? And that's where we go back again. 2402 really should be signed in advance of the offer. And then once you have that established, it should be referenced here, right? This is referencing, so it's contained in one document. That's here's what we agreed to outside of it. And so yes, if you have it, and let's look at it a little differently. You have the 2402 signed. You should use this addendum and reference it so it's all in one place, right? It's in the contract. Everybody sees it. The title sees it. The buyer and seller see it. And so then you would put whatever was in that 2402 in the blanks here that's referenced in D1. And do I recommend 2401 over 2402/6 in situations where 5B is filled out on the listing agreement, which is hard to know as the buyer. So if we look at 5B, to circle everybody back around to that, is 5B is this section that has broker fee without compensation for other brokers. And so even if you have a listing agreement that is X without compensation to other broker, doesn't mean that they won't agree to it, right? So but if they're firm on that and they stick to it, the 2401 is there the seller paying. And I think that's a logical practice situation that will arise. And yes, I would use the 2401 in that case, because then you're establishing the seller paying directly. And that's likely what their intention was going into it, right? So they won't have to have a new discussion with the listing broker saying, oh, you're paying some of that now. We're changing up our arrangement between the listing broker and the seller. That allows them to have probably this similar discussion of, hey, up front, I said, you're only paying me. Here's an offer that came in 2401, they want to establish, let's sign that. That's you agreeing to pay like we talked about them directly, if anything. And so yes, I think I would use the 2401 in that situation, because 2402 could maybe not fit in with what they had discussed in advance when doing the listing agreement. How do we get signed up weekly for these meetings? So we'll do a new registration each week. We'll flip it over. I'm trying to find the best format for these. To be quite honest, this started with just coffee conversations or going out to the bar in the evenings and just talking about real estate. I geek out on this stuff, and I wanted to provide a platform to be able to talk to it. And I thought, a few dozen, a couple dozen people might show up, and it's great seeing over 50 people on the core of this conversation. And so we'll work on the format. For now, we'll put a new registration link up. Their Zoom has an ability, if we stay with this platform, to have it open for all the meetings. And this one, I talked a lot more. I want to have more interaction in the future. I want to be able to have you ask questions and what's on your mind instead of a talking head. Let's dive into what's in your thoughts. So let's see, any other, and we're right out. I'm going to try to keep these right at an hour each week out of respect for everybody's time. And Kiersten, I can't thank you enough for jumping in. As we were talking about this, she said, how can I help in any way? And this is just her volunteering to jump in to be a part of this. And I can't tell you how much I thank you for helping coordinate this. And I'm going to look forward to every week having this open. So send your questions in advance too, because that allows me to tee up my platform and what we do to better address that and to put that in the presentation. But I always want to try to keep this live component and have more of that at the end to have that group learn, the group thought, the questions that you have that you may not, be brave enough to ask, somebody else might. Or if you are brave enough to ask one, it'll help everybody out. And I'll tee that up, send them in. We have a Facebook page, Special Provisions on Facebook. It's brand new. We'll use that as a vehicle and tool to put out there. Last thing I'll say too is we'll have different series. We'll have contractual out series. We'll have various different series that we'll be putting out there to dive into these things. And really give back. We love what we do. We love talking about this and helping out. So Kiersten, any final words? Thank you again.
It was fun. I am going to pull for Nora, if you want to hang on a second. I'll pull the link so you can see which forms are available in Spanish. I will tell you that there's a lot of administrative items that have to be cleaned up, both with TR and things that TREC are looking at. So I did a presentation in the morning and I said, y'all just get ready, embrace change, because we're going to have a lot of it over, I believe, the next 12 to 24 months, actually. It's going to be fun.
And I see some great take classes from these instructors. Kiersten offers great classes and everything. I see in center of my screen here, Ed Zapata with Cuba Realty. He's on here. He is teaching too. He's on STABOR. He's going to be in Secretary Treasurer coming into STABOR. And we'll have some of these open discussions. I'm going to try to get some of these guys to help present or have interviews with them. But yeah, get good instruction on these things. Let's talk about it here. And I love how everybody's diving into this and wanting to learn. So we'll see everybody hopefully next week. In the meantime, don't hesitate to reach out, give us your questions, and we'll see you then.